Welcome to Canadian Justice. Today we are talking about the public's right to know what happens during court proceedings and a case that is asking the Supreme Court of Canada to consider further restricting this right. On December 15, 2017, billionaires Barry and Honey Sherman were murdered in their home in Toronto, Ontario. The Shermans were prominent Toronto residents, and Barry Sherman was the chairman and CEO of Apotex, Canada's largest producer of generic drugs. To date, the murders remain unsolved, and the case has sparked intrigue and controversy all over the world. In 2018, Kevin Donovan, the Toronto Star's chief investigative reporter, made an application to the Ontario Superior Court of Justice to have the court files unsealed and to be made public. And this application is based on what is known as the open court principle, which requires that court proceedings be presumptively open and accessible to the public and to the media. To discuss this case with us, we have Justin Safayani from Stockwoods LLP and a member of the Canadian Media Lawyers Association, and Eva Krajewska, a lawyer who acted for the Income Security Advocacy Center, who intervened in this case. Thanks so much for coming on the show today. Ms. Krajewska, can you just give us an understanding of what was Mr. Donovan looking for with respect to his request to have this file opened up, and maybe give us a little bit of background of the facts on this case?
Right. So as you said, Mr. Donovan had been investigating the murders of the Shermans. And he went to the court office, the estate's office in Toronto, to get a copy of what is called a application for the certificate of appointment, or a probate application, to get a copy of the will that the Shermans had left. So if you pass away and you have a will, you may have to bring a court application to the court, which is public, to have that will be verified as the last will of the person who passed away. And that's an open process. And if somebody wants to challenge the will, they can do that through the court process. So he went to the court office to get a copy of the Sherman's wills, and he found out that that file had been sealed. And so he brought an application to the Superior Court asking the judge to unseal the file, or asking for justification or reasons as to why it was sealed. And the judge said that the estate and the estate trustees were represented by counsel, and they said, well, we need this file to be sealed because we want to protect the privacy interests of the Sherman family. And there is also a potential risk of harm to them, or a danger to them, if this murderer or murderers or whoever committed these crimes are still out there, and they may, there may be a risk to the beneficiaries, the Sherman family, whoever is named in that will. So the judge agreed. It went to the Court of Appeal. The Court of Appeal disagreed and said, no, we don't think that the privacy interests here are significant enough to override the open court principle. And then it went to the Supreme Court, and the Supreme Court heard this at the beginning of October, and the decision is on reserve.
So, Mr. Safayani, when we're taking a look at this, obviously, if there's a disclosure of the will, we're going to be able to see all of the assets of the estate, everything that the couple would have owned prior to their death, as well as those that would have the right to inherit that, the beneficiaries and such. Is this something that's common in media, to be making requests for the courts for these type of files?
Well, I mean, I think it arises probably less in the context of estate proceedings. But, the media's interest can lead it to all sorts of different types of court proceedings. The most typical thing that you see is in the sphere of criminal proceedings, of course, where there is usually a high degree of media interest in those proceedings. The cases are closely followed, and the media want to be able to get access to exhibits and records that are adduced in the course of those proceedings. But the media's interest can extend to other types of proceedings as well. It can extend to civil proceedings, commercial proceedings, family law proceedings, and in this case, estate proceedings, which is a certain type of kind of civil law application. So it's not unusual to see the media have an interest in civil cases as well as criminal ones. Although I think it's fair to say that this is probably one of the most interesting estate proceedings from a media perspective.
We're gonna come back right after these commercial messages. Welcome back to Canadian Justice. I'm here with our panel of experts. We're talking about the Sherman murder and how it has sparked a question about the open court principle in Canada. Mr. Safiani, you were just finishing off, I believe, on your comments on media inquiries with respect to estate matters, as is the case with this matter. But give us an understanding. What is the position of the Toronto Star that's being advanced here, where they're saying that they have a right and that the open court principle should be respected here? What is the legal position that's being advanced?
So I think there's a number of arguments being made, but there's two kind of key ones that I think lie at the center of the case. And they have to do with the first stage of what's kind of a two-stage test that the estate and the estate trustees have to meet if they want to keep this stuff under seal. So the starting point is a presumption that in a court proceeding like this, the documents are publicly accessible under the open court principle. If you want to get around that and convince a court to impose a sealing order, as the state trustees did at the Superior Court of Justice level, you have to show first that the sealing order is necessary to prevent a serious risk to an important public interest that can't be protected by other reasonable alternatives. It's a bit of a mouthful, but that's the first part of the test. If you show that, then you also have to meet the second part of the test, which is that the benefits of the order that you're seeking, the sealing order, outweigh the negative impacts of that order, including impacts on free speech and on the public interest. Most of the arguments in this case, the interesting ones, at least from my perspective, deal with the first part of the test. And the first big issue is, at what point does a privacy interest, the desire for the estate trustees and the beneficiaries to maintain privacy, rise to the kind of important public interest that could justify a sealing order under the first part of that two-part test?
So let's take a look at that issue, because Ms. Krajewski, your client is actually advocating that privacy rights should actually rise up to the level of the public interest, I guess, stature or place of where the open courts principle is here. Maybe if you can give an understanding of your client's perspective, and I think some of your client's perspectives are shared with the Sherman family's perspective as well.
Right. So, I mean, the Sherman family, or the Sherman estate, advocated that privacy and protection of privacy is a sufficiently important public principle, and that could override the open court principle in some circumstances. So, they rely on we recognize privacy as an important interest in society. We have a lot of privacy legislation. The Charter protects privacy. So they're coming at this from, the courts have never really recognized, though, up until this case, that privacy in and of itself is an important public interest. I mean, my clients want to take a bit of a step further, or a bit of a nuance on that position, which is when you have a privacy interest and divulging that private information would cause harm or would prevent you from accessing the courts, then that rises to a sufficient public interest. And that's been recognized in the jurisprudence. I mean, the Supreme Court found in a case called AB that a teenager who was the subject of cyberbullying, her identity should be protected, because not to protect her identity would lead to more harm to her and that she'd already been subjected to. So there are times, and we see it in sexual assault claims, we see it in family law proceedings, where the courts have been prepared to prevent harm to vulnerable persons, where disclosing private information about them would cause that harm.
Okay, and it's interesting. So you're saying that the Shermans in this instance are saying that they wouldn't be able to really have access to the justice system if they knew that they may be harmed as a result of the application that the estate brought forward. Is that one of the arguments that's being advanced?
Yeah, well, I mean, they're in a bit of a difficult position because they probably need to probate this will. So they need to go to the court and have the court approve the will. Otherwise, they may not be able to, sell certain real estate or access certain bank accounts. So they're in a position where
I'm gonna let you pick up a little bit more on that after these messages. We'll be right back. Stay with us. Welcome back to Canadian Justice. I'm here with our panel of experts. We're talking about a case before the Supreme Court that's questioning whether there should be further restrictions on what is known as the open court principle. Ms. Krajewska, I had to interrupt you before the commercial message, but you were basically just talking about the necessity of the Sherman estate having to bring this application, and so sort of being in this spot where they're forced to bring this before the court, but yet they're advancing that there may be some security interest at play.
That's right. I mean, people sometimes try to structure their estate affairs in order not to have to go to before the court. But here, obviously, they had to go before the court, and that will lead to divulging a number of probably private and confidential information about the family. And they are asking the court to seal that information so that it does not become public, it does not go to the media. It's not otherwise disseminated. So they are in a bit of a difficult position. I mean, there's other situations where someone can argue, if you don't provide me with a sealing order, I can't come before the court, or I'm too afraid of coming before the court. And that's bad for access to justice. That's bad for the administration of the courts. I mean, we don't want to prevent people from accessing the courts because of fear.
So, Mr. Safayana, maybe give the viewers an understanding of the background of the open court principle and why this has been important from a democratic perspective to Canadians.
Sure. So, I mean, it goes back decades and decades in our Supreme Court's jurisprudence. There's so many cases that kind of explain and reinforce how important this principle is. But really, it come down to kind of four different reasons why the court has said this is important. The first is the court has said, maintaining open courts helps us maintain an effective evidentiary process. The idea here is that if there's a degree of public scrutiny over what's happening in court and what documents are filed, witnesses and the parties are more likely to behave honestly, because what they're going to say and what they're going to do is not only going to be reviewed by a judge, but by the public and perhaps the press. The second, and I find this to be personally the most compelling reason, is that it ensures judges and juries behave in a way that's fair and sensitive to society's values. The idea here is that having the public be able to see and understand what's being done in the court promotes a sense that decision makers are accountable or at least visible to society. The court put it in one decision, the very soul of justice and the very security of securities is the open court principle, because it acts as a guarantee that justice is being administered in a non-arbitrary manner according to the rule of law, because people can see that for themselves. Mm-hmm. The third rationale is that it promotes a shared sense that our courts operate with integrity and actually dispense justice. This again goes to the legitimacy and transparency of the process. And finally, it provides an opportunity for the community to learn about how the justice system operates and to see it in action. This is, at the end of the day, a public system. It's paid for by the public, and the public has a right to see what's unfolding within that system, unless there's a really good reason why it should be kept secret. The last thing I'll add just quickly is that courts have also recognized that the way the open court principle, actually manifests itself in practice is often through media access. People don't have time to go sit in a courtroom or rifle through boxes of court files themselves. It is the media that's often the conduit between the public being able to see what's happening and what's actually happening in a courtroom.
So, Ms. Krajewska, we're clearly seeing the outline of the public interest in the open court principle here, but you're saying that the privacy interest is actually something that's also raising to the level of a competing public interest. How do we start to explain that in this case? Because it's my understanding that the court actually has the ability, even if somebody doesn't meet the first element of the test, that the court can actually redact and remove names and such. How do we balance out this issue? Is it really a privacy issue in this case, or is it really somebody just wanting to make sure that certain family information is not divulged?
Right. I mean, I think so. The Sherman estate has to meet that first part of the test. They have to meet it. It's really at the second part of the test that the court then does, what the court does a lot, which is balance. It balances whether here the benefits of a sealing order outweigh the harms of a sealing order, and the harms to the sealing order or the harms to the open court principle. So they're going to weigh those two things. And it's also at that stage that the court may ask, are there other ways of achieving protection?
I'm just going to cut you off there. I'm very sorry. We have to go to a commercial break, but we'll let you pick that up in just one moment. Welcome back to Canadian Justice. We're here with our panel of experts. We're talking about the Sherman case that's before the Supreme Court of Canada, talking about further restrictions on what is known as the open court principle. Ms. Krajewska, I'm sorry I had to cut you off before the break. If you might just be able to pick up, I think I posed to you the question, is this not something that could actually be dealt with within the current rules where judges actually are permitted to be able to redact or to take out names and security interest or otherwise?
Right. So the court is always going to try to find a manner that is the least restrictive on the open court principle. So if they can redact names, if they can use initials, or if they can do a publication ban. So for example, the court file is open and you can go and read the court file and find out what's in the court file. You can sit in the courtroom, but you can't write about certain information. So there's a whole kind of spectrum or gradation of tools that the court has to protect the important privacy interest, but then also balance against that the open court principle. And I will add, I mean, the courts have always said, we're not going to grant you a sealing order just because the facts are embarrassing, right? Like just because something is embarrassing is not enough to grant a sealing order. And it goes back to the importance of the court principle. But the court does have a lot of tools in its toolkit to try to prevent harm and protect the vulnerable. And it does that a lot in family court proceedings. Like in family court proceedings, the names of children are routinely put in as initials, right? There is an ethos of trying to protect the vulnerable who are not necessarily before the court by choice, but because they have to participate in a proceeding.
So, Mr. Satriani, just returning sort of back a question to you in this respect for the media, when we're taking a look at an application for the estate, I think the estate information that Mr. Donovan is seeking here, we're really not taking a look at the evidence in a court proceeding or the reasons of a judge that's coming out. It's really the personal details of a family estate. Is this something whereby the right for the public to know these intimate details should actually be restricted, or are you saying that in all instances that this should be something that the public should have a right to?
So, I mean, the Supreme Court has been clear that the open court principle applies, across the board at all stages of all court proceedings. So it's not the case, although this is an argument that appears in the estate's materials. It's not the case that just because it's not as contentious a proceeding as some other types of proceedings, for example, a criminal trial, that there's a diluted version of the open court principle. And at the end of the day, I mean, this is not just kind of forms being filed. I mean, my understanding is that there is sworn affidavit evidence. It is a proceeding that requires a judge to look at the evidence and make determinations, even if it's not as contentious as some other types of proceedings. So I do think it still applies. Whether the rationale for getting the documents is as compelling at the second stage of the test as it may be in some other situations, and that may be open to some debate. But I return to the fact that I think the more interesting parts of this case are at the first stage of the test, and this idea of privacy plus what is going to be enough. The court so far has been quite clear that pure privacy interests aren't going to be enough, but it's also been clear that privacy plus something more will be enough. What is that something more?
Very, very, very interesting to see this area of law develop. We'll look forward to the Supreme Court. I think that they'll be issuing their decision in anywhere from 3 to 6 months. So we'll wait and see. Thanks so much for coming on the show and sharing this with our viewers. Today we heard about the concept called the open court principle and the public's right to know what is happening in our courts across the country. We looked at competing claims for what constitutes the public interest and the growing public's concern for privacy rights. Former U.S. Senator Christopher Dodd stated, "When the public's right to know is threatened, and when the rights of free speech and freedom of the press are at risk, all other liberties we hold dear are endangered." So what do you think? Should the courts continue to safeguard the zealously protected democratic principle that provides the public the right to know what is happening in our courts in our country? Or is the growing concern for privacy shifting the measuring stick for what is a paramount public interest? You be the judge. Thanks for watching Canadian Justice. I'm K.R. Davidson, reminding you, keep examining and know that you are part of the solution.